Good morning. Welcome to the First District Court of Appeals. We have 4 cases to be argued this morning, and we will be taking a brief recess in between the first 2 and the second 2. When I call your case, please stand and state your name and your readiness to proceed. The first case this morning is C-24-0145 in re TC.
Justin Walls on behalf of the appellant TC, ready to proceed.
Gilbert Wessels on behalf of the appellee, the state of Ohio, ready to proceed.
Thank you. The second case is C-24-0338, Ho versus Co.
Justin Cole, ready to proceed.
Thank you. The third case is C-24-0158, State of Ohio versus Wright.
John Hill on behalf of the state of Ohio, ready to proceed.
Thank you. And the final case is C-24-0151, State of Ohio versus Michael Thomas.
Good morning, Michelle Berry on behalf of Michael Thomas, ready to proceed.
John Hill also on behalf of the state of Ohio, ready to proceed.
Thank you. All right, we will begin with the first case, C-24-0145. Ms. Moss, you may come forward. Would you like to reserve time for rebuttal?
Yes, Your Honor, 3 minutes, please.
You may begin when you're ready.
Good morning, Your Honors. May it please the court. This case involves TC and KS, who are in a sexual relationship with one another, where TC challenges his adjudication as well as his classification. And I want to first focus on the second assignment of error, where TC was denied the effective assistance of counsel. And had TC's trial attorney filed objections to the magistrate's decision regarding sexual imposition, there is a strong probability that the juvenile court would have reversed the magistrate's decision.
Now, what is it that we should be looking at as a lens? You're calling it a strong probability. What's the actual lens that we should be looking at?
When there is no objection to the magistrate's decision, Court of Appeals is required to look at ineffective assistance of counsel, but through the lens of the juvenile rules. And that came from In Re LC,
Okay.
Discussed that. Here, there was no opportunity for the juvenile court judge to review the inconsistencies in the magistrate's decision. And this was prejudicial to TC, considering that under the review at the juvenile court level, there is no evidence being in a light most favorable to the state. There's no reversal only in exceptional cases of a manifest miscarriage of justice. There has to be an independent review. So it is a lower burden and bar to get over than would be reversal at the appellate court level. But we know that this
And while that might be true, it's sort of interesting also that if there are objections that had been filed and it would have been de novo review, that the findings of fact, while de novo does not require a new hearing or the taking of evidence and so on. So what should we do with that?
So we still have to, this court can look at what evidence was presented to the juvenile court at the trial level to determine.
No, I understand that, but what I'm saying is if objections had been filed, the trial court wasn't obligated to take in any evidence, witnesses, or anything. They were able to do a paper review under de novo on findings of fact.
If objections had been filed, they couldn't just do a paper review. They would have actually had to do an independent review and review all the
Correct,
transcripts
right, but it would have been a
evidence.
paper review. It could be a paper review.
Correct.
Do you think that that affects anything, I guess is really what I'm asking.
I don't think that affects anything, and it also makes it more likely they would have reversed when there are 2 cases in Ray JH and in Ray MCL that were reversed at the appellate level on manifest weight grounds, and especially the JH case. There are a lot of similarities to TC's case to that in Ray JH that would make the reasons that that adjudication did not stand in
Counsel,
JH.
does your argument, as I understand the prejudice prong of Strickland and what you're arguing, in essence, you're saying that TC lost the opportunity to have this independent review by the juvenile court because his attorney did not file an objection. And so does that require us, in essence, to conduct this independent review to assess what would have happened had the trial court, in fact, conducted one?
I do think it does require this court to conduct an independent review to see if there would have been a likelihood, to see if then there was prejudice in looking at what evidence would have been presented at the trial court level.
And can you walk us through that analysis? So what would the independent review have resulted in?
So if we look at even under the appellate review, normal appellate review with JH, you have issues with KS was not credible and was willing to lie. She, even in her initial statement, told police that TC followed her to the park. She misconstrued her relationship with TC. Reviewing her description of her clothing and how if there was any touching, it could only have been consensual because there is no other logistical or practical way that it could have happened the way that she described.
I understand what you're saying, but it seems like the text messages kind of cut against that argument, though. Because, I mean, at one point, he is telling her to tell them it didn't happen even if it's a lie, tell them you were joking. And then she said, what you did was bad and you know it, you haven't apologized, you asked me to lie to them about what happened. And his immediate response after that was, I'm so sorry, I really am.
So while there were some sort of admissions by TC, it was not clear to what TC was admitting to. They were,
So we can't look at those text messages in context of what they were saying in the text messages?
I think this court can look at the text messages, but it is also similar to the case of In re JH, where the 9th District determined that there were other reasons that the child in that case may have apologized, may have told the girl in that case not to tell anyone. And so for the same reasons that there were other reasons to justify those statements, here there are other reasons. The text messages also included information not relevant to the allegations here. There was a conversation about TC looking to get in a fight with someone else, but he never specifically admitted to engaging.
Counsel, can we interpret his silence in the face of the allegation as an admission? At one point, KS describes the conduct, and his response is something to the effect of, okay, and I hope your father doesn't go to the school, or something to that effect. Can we interpret that response rather than a denial as an admission?
I don't think that we can interpret that as an admission because there were other messages where right from the get-go, TC was shocked that KS was accusing him of doing anything, and even went further to say, I didn't do anything, I didn't try to force you to do anything. So there was inconsistencies even within those messages and other explanations for why he may have made those statements. He was also afraid. He was afraid that these other individuals that tried to fight him were going to kill him, and so that may have also contributed to why he was asking her to tell these people something different. But he very clearly opposed right from the beginning any allegation that he tried to force her to do anything.
If there are competing inferences from the text messages, so if there's an inference or a way to read the text messages that would corroborate and support her version of events, and then another way to look at them in a way that would support his denial, is the juvenile court at the independent review stage required to accept one inference over the other, or may it choose from either set of inferences?
The court can choose from either set of inferences, and that's where when you're looking at the big picture here, the magistrate determined that as to the allegations of rape, that those allegations could, not only did KS make that statement later on, but the magistrate determined that KS that could not have happened physically as KS had described, and so for a lot of the same reasons that the rape allegation could not have occurred, this sexual imposition allegation could not have occurred the way KS described, but the juvenile court would have been free to take either set and not look at it in the light most favorable to the state.
So then how is it prejudicial if the juvenile court ultimately could have reached the same outcome that it reached? How is it prejudicial for TC's attorney not to have filed the objection?
Because even if it would have been upheld by the juvenile court, on appeal, had objections been filed, then there would have been the ability to review under sufficiency and manifest weight of the evidence. And when we have two other cases that have reversed on manifest weight grounds, one being very similar to TC's case, then that makes it more likely that there would have been a reversal even on appeal, even if the juvenile court would have upheld the adjudication.
Attorney Moss, the way you answered that question was something that I also kind of picked up on in your brief. It sounded to me as if you were partially arguing that the loss of the opportunity was the prejudice in and of itself. Is that what you're also trying to argue, or am I reading too much into it?
I think the loss of the opportunity is part of this problem because, if we wouldn't have this other case law where there have been reversals on similar grounds, then I don't think that there would have been prejudice because there wouldn't have been a reasonable probability of reversal. But here, there certainly was at the juvenile court level, but as well as at the appellate
And
level.
I understand your argument. I understand where you're coming from. Have you found any authority to support that sort of, that thought of like the loss of the opportunity itself becomes the prejudice, and also becomes, obviously the IAC is not doing the objections, but then the loss of the opportunity is the prejudice?
I have not found any cases that specifically look to that because generally there's not that other case law that would support reversal even at the appellate level on the manifest weight grounds. In this case, additionally, TC would not have known that any sexual contact, if that occurred, was offensive to KS. So although KS may have initially said she did not want to engage in any sexual contact, there was additional communication between the two of them where KS seemingly conceded to engaging in some sort of sexual conduct, just telling TC not to take it too far. And the only qualifier in TC's response was, okay, I agree not to have sex. So, that runs a gamut of what the two of them were agreeing to. And it wasn't just that, it was an agreement not to engage in any sort of sexual conduct. There was no description of what too far meant. Additionally, the nature of their relationship is important. They had a sexual history with one another. They had plans to go to the park to engage in further sexual history with one another. KS told TC he did not need to ask permission to engage in any sort of sexual activity with her. And so those make this case distinguishable from the other cases where there wasn't any kind of prior sexual history or relationship between the two individuals. And when we look at going to the first assignment of error, as well as the part in the second assignment of error of the corroboration piece, here, even though corroboration is a low bar, it still has to be something that makes KS's statements more likely. And when we factor in that KS was not credible, that she lied even in the statement to police from the beginning, and the nature of the relationship between the two of them, that calls into question her credibility. We also have the juvenile court.
So it sounds like you're asking us to first to excise certain testimony in order to get to the no corroboration.
So we have
Because
to
there
look.
is evidence there that could, ultimately it seems that what the magistrate believed is, for example, when she left the park, that she went and informed these people about what had occurred. And there's case law that seems to support that that's sufficient for that low threshold of corroboration. Your position is that she's not credible, so it almost sounds as if you're asking us to excise certain pieces of evidence in order to determine whether there's corroboration.
It's not just that she wasn't credible, so it requires there be some other corroboration besides just her testimony. So her testimony of telling other people, those people didn't come in to testify, that can't be corroboration. This case is different than the numerous other cases where somebody else immediately after witnessed the alleged victim and saw their demeanor, their reaction. That wasn't the case here.
And counsel, you are out of time.
Thank you. Just briefly, I do just want to quickly touch on the third assignment of error, that this could not have been solely about unlawful sexual contact with a minor. That would not be the only basis for the exemption. This was clearly some sort of consensual sexual conduct between the two, and I will reserve the remainder of the time.
Thank you.
Good morning, and may it please the court, opposing counsel. Unless the panel has any specific questions, I'd like to address, I guess, the second assignment error, which is what appellant mainly addressed during the course of her argument. I think to go to the second prong, and the state did argue in its brief that they have failed to demonstrate prejudice as to either prong. We argue both that there was that counsel did not violate an essential duty, and also that they cannot demonstrate prejudice. There's, I think, something that was referenced by Judge Kinsley, which was, or maybe it was, I think both Zayas and Kinsley brought up this idea of prejudice and the review of de novo. I think it's important to understand that the ineffective assistance counsel is the failure to file this objection, which I guess the idea when we're looking at ineffective assistance of counsel under that second prong is whether or not that failure resulted in some sort of prejudice. And so,
And that's, that's like where the loss of opportunity kind of, maybe that's where we're going, I don't know, The brief seemed to kind of lean that way in addition to arguing it in a more traditional fashion.
right, and I think ultimately, and I think the reason that is because ultimately when you get to this idea of when they were denied that de novo review by that higher court, it goes to what Judge Kinsley was saying about the court is not bound to, that court on a de novo review is not bound to accept the determination. But although they're not bound to accept it, they could have accepted. And obviously the magistrate was in a better position to judge and determine the credibility of the witness, which as appellant argues is one of the main things that this case turned on. I think more than anything, it's because the case, to the magistrate anyway, seemed to turn on the credibility of that witness. It seems to be more likely than not that a judge reviewing the issue de novo would have accepted that magistrate's credibility determination. And if that was the case...
And seeing that goes to what the interesting thing about juvenile court is that it gives the trial court de novo, but at the same time also these findings of facts are not necessarily bound to having to have a hearing and witnesses and so on. So you have a trier of fact who already reviewed the demeanor of the witnesses, right? Made an assessment of credibility, and now you have a trier of fact who's going to not review the demeanor of the witnesses and make an assessment of credibility on paper.
And in order to establish that reasonable likelihood of that there was some prejudice, I think the case law is clear that it has to go beyond mere speculation. And in our argument, in our brief, what we argue is all they can do is speculate that a judge would essentially take it up to a de novo review and disregard the magistrate's credibility determination, disregard some of the facts that point against it, and essentially come to a whole new finding in opposition to what the magistrate found. And I do not think that that has been demonstrated here. I think the determination of the magistrate, which was included in their decision, supports that determination. In fact, I think the argument being raised on appeal under ineffective assistance of counsel has essentially already been rejected by the magistrate. This idea that because the victim was not credible in regards to the rape, that she couldn't be credible in regards to anything. And as the magistrate pointed out in their determination, there were deficiencies as to the victim's claim of rape that did not exist for the sexual imposition.
And wasn't it clear from the magistrate's determination that the magistrate viewed the text messages as being an admission by TC?
Correct, and I think within her decision, she specifically said that viewed in the context of all the text messages and the testimony of the victim, it's clear that he was specifically apologizing for his behavior at the park. Obviously...
It's not a big deal, but the magistrate was a he.
Oh, sorry about that, he.
Well, I mean, he might be watching and he,
Well, regardless, I think that, and I'll apologize to him if I say this. I think that the determination of the magistrate in regards to viewing the evidence, specifically in his decision, viewed the evidence in the way that the state views it, which is consistent with the victim's testimony, She had set a clear boundary. What she said to him in the text messages before they went to the park is, "I don't want anything sexual." Regardless, they went to the park. He engaged in that sexual conduct, which she reiterated to him. And as Your Honor pointed out, he said, well, hopefully he doesn't go to the police about what I did, or hopefully he doesn't go to the school about, or your dad doesn't go to the school about what you told him. And I think all of that, read in context, supports this determination that she was raising to him what he had done was wrong. He knew exactly what they were talking about, and he apologized for it because he knew at the time that it was wrong.
And on independent review, is it your perspective that had that independent review been conducted, the juvenile court could have accepted the magistrate's determination that these were admissions, or could have gone in a different direction and read some other inference out of the text messages? Either way.
Not only do I think a court could have accepted that, the trial court, the trial juvenile court could have accepted it. I think, relevant to this court's review, I think that given the deference that's paid to the magistrate's decision upon a de novo review, I think that the trial court was likely to have accepted it. And because of that, that's why we say that the prejudicial prong of Strickland is merely speculative at this point. All they can do is speculate and hope that a court would have accepted it, which I think it's to Judge Zayas' point about really the prejudice that they're alleging here is that, man, we wish we could have raised manifest weight or sufficiency, but because there was no objection that was raised, we're stuck here on plain error review. I have not seen anything cited, and I'm not aware of any cases that the prejudice that can be established is we wish we had a better standard to bring up to the Court of Appeals. I don't see the prejudice that results in that, especially in the case.
This sounds sort of like legal prejudice or procedural prejudice in some way, rather than outcome prejudice. And outcome prejudice is the Strickland standard, right?
Correct. And with regard specifically to the Strickland standard, I mean, obviously there's a deference that's paid looking at the position of the actual trial attorney at the time, not forward-looking or backward-looking to what may or may not happen in the future. I don't think that I don't know of any case law to support the proposition that the trial attorney has to be, I guess, considering his own effectiveness as it relates to the standards that they may raise on appeal, specifically as it relates to a juvenile case where there is a magistrate determination where they may, quote unquote, lose that I guess you would call it a quote unquote better standard for them on appeal. I just don't think that they can establish prejudice in that way, because the Strickland standard is going to look at as Your Honor put it, the outcome prejudice, whether or not had they failed to make that error, whether it would have caused any issue at the trial court, whether that prejudice would have existed there.
So going back to credibility, there were a couple things that were highlighted this morning in the arguments by Attorney Moss. One is that the statement of the victim was inconsistent with her ultimate testimony as to going to the park and as to being then followed, as opposed to going together with TC to the park. The other thing that she highlighted was that based on her attire, that it was an impossibility for the actions that were testified to as to the sexual imposition to have occurred. Can you address those two and how we should be looking at those with regard to credibility?
With regards to credibility,
and obviously our plain error review.
right? I mean, I would defer to the credibility determinations of the magistrate and focus on. Realistically, I think, in order to come to the conclusions that appellant is coming to, I think the only way that you can come to those conclusions is by divorcing the various fact patterns down to just single facts, not viewed throughout the context of the whole encounter. I think when viewed, the text messages, TC's own admissions, and the testimony of the victim, I think it paints a clear picture of what exactly happened. I don't know if I'm specifically answering, if there's any specific fact that the court would like me to address.
Well, I think, one of them is the attire. When we're looking at both credibility and even manifest weight, if there's evidence that, that shows like, look, it's impossible for the testimony to have been credible because this evidence is so clear.
I know that the attire was part of part of the magistrate's determination of specifically to the rape count, whether or not.
That was, exactly.
Right, and
But it was argued today, as if it also applied to the sexual imposition, that there was something about the attire that made the actions that were testified to on the sexual imposition an impossibility to carry out.
Maybe I wasn't hearing it correctly, but I didn't hear that as the offered proposition. But I don't think, at least in my understanding of the evidence and what she was wearing, there's nothing that she was wearing that would have made a sexual imposition impossible. And I do think that her testimony was consistent with the factors. I did want to, and unless the court would like me to elaborate more on that, I did want to briefly address the third assignment of error, unless the court has any specific questions about that. I do think that the case from the second district that the state has cited and that the trial court relied upon is persuasive, and I do think that their determination is a correct one, that a fact finder would necessarily have to reject this understanding of consent in order to convict someone on a crime like this. And
Is
so-
there some meaningful difference between the word consent and the word offensive? I mean, those are two different words, so do we know why the legislature defined these two provisions differently?
I don't. I think it focuses on, and we kind of bring this up on our brief, the understanding that at least for the sexual imposition charge, the focus is not so much on whether or not, to the extent that any of us can define what actual consent is, whether or not consent existed is not necessarily determinative of the issue, because I think the determination of consent, at least as I understand it, would involve both parties. But here, the sexual imposition standard focuses on the mind state of the perpetrator. Obviously, our position is that whether or not he believed he had consent is relevant to that determination of whether or not he knew or believed or was reckless in disregarding the offensive nature of his contact. But I don't have information for the court about the legislature's decision other than I believe that that's sort of what it focused on, is that they intended to focus on the mindset of the actual defendant at the time.
So one of the text messages that he sent said that he apologized, he's such an F up, and I never take signs. The fact that he didn't properly read the signs, could that be read as he didn't know it was offensive?
Sorry, maybe you can, I don't know if it's possible to phrase it another way. I'm trying to get to what
Okay, so he said that, he apologizes, he never takes signs, which, could that be read as that she might have signaled that she did not want this to go any further, but the fact that he did not read the signs properly, could that be interpreted as that he didn't know what he was doing was offensive?
I think it could have been interpreted that way. Obviously, the determination of the magistrate was differently, but if the question is whether or not that specific fact could be taken into consideration for that element of whether or not he knew that his actions were offensive or was reckless in disregarding, yeah, I think a court could have made that determination. Obviously, in this case, the determination of the magistrate was that she set a boundary ultimately, and I think even consistent with, and obviously the court believed her testimony. Her testimony was that she specifically told him to stop. Had she not actually said stop and was only giving outward signs, an examination of those signs would be certainly relevant, and a court could make a determination based on that as to whether or not he knew or should have known or was reckless in disregarding those signs.
And then the way he ended that particular text, he said, I never take signs and listen.
Right.
Does that change it?
In regards to whether or not a court could consider it, no, but I also think it supports the trial court's determination that there was something said for him to listen to and then disregard, whether it was signs or oral. Unless the court has any more.
Just one clarifying question. So as to the registration issue, is it the state's position that all offensive sexual conduct is non-consensual? So is offensiveness a subset of consent?
I can't stand here and say I've viewed every offense that uses the term offensive, and there could be a situation, I guess, where the term offensive is used, but at least as from upon my review of the case law, it seems like, and I've cited a couple of different cases, in most cases, a determination, at least in the sexual imposition context, is that term offensive is essentially synonymous with the lack of consent.
Is it synonymous or is it implicit? Because I think the cases use the word implicit. I don't know if there's a big difference.
There probably is a difference, and I would say it's closer to an implicit than it is synonymous. I don't think you can necessarily substitute one for the other, but I think the important question is that, or the important proposition that we're making is that when we find that they've disregarded that that offensive conduct, or that they knew it was offensive, that finding, I think, obfuscates the need to find, or necessarily when you make that finding, I think you're necessarily rejecting consent as I guess a defense.
Yeah, I hear what
that.
you're saying, because if it's offensive, then, generally people don't say, yes, I love that offensive thing, please do it to me.
Right.
Because offensive by in nature means that it's undesired in some way.
And when you're speaking to the mind of the defendant as well, I mean, there could also be circumstances outside of, and I think this is more why we focus on offensiveness rather than consent, because there could be other reasons that they don't know that it's offensive, like a sexual touching. I mean, I'm coming up with now, but if there's a culture, they do a touching that for cultural reasons they believe is appropriate to do, or they have some other form of reason to not suspect that a touching, like in some kind of sports game or something like that, would have nothing to do with consent, but may still have to deal with the offensiveness. I hope I'm making a clear enough
Yes,
distinction.
and just to clarify procedurally, I mean, it is the case that the tiering of the sexual registration is going to come after there has been an assessment of guilt.
Correct.
And so it's going to be the case that there is already a finding as to offensiveness if we're dealing with a sexual imposition, and that trial record would determine whether there had been consent or not.
Presumably. The Economo case, I think it was either Economo or Raver, they stated that like a brief on the findings that were already in the record could satisfy in absence of, I think the implication there is that a whole new evidentiary hearing is not required. The only situation that I would think would be different is in the case where someone pleads to something. That was the case in those other juvenile, but even as I understand it, a plea to sexual imposition, which obviously is not the case here, I still believe that a guilty plea to sexual imposition would result in still that finding of
You said something
non-consent.
earlier that ties it all together. In reality, and it's the way that it's phrased, that it's really you're looking at it from the perspective of the victim, and there's case law about that. So it's not about whether and of course there's a reasonableness to it, but there's an objective and a subjective. So it's not about whether the accused, what his or her perspective is, but the alleged victim, whether it was offensive.
It's actually the state's proposition that it's the other way around, Your Honor.
You think the offensive is based on the
The whether or not, at least to the whether or not it focuses on whether or not the defendant knew it was offensive to
correct,
the person and
but it has
disregarded
to
that.
correct. But the offensiveness, the determination as to whether the conduct is offensive or not,
Right.
is from the perspective of the victim.
That's correct. That's correct.
That's right. So that all then ties right back into the implicit nature of the consent.
Right.
Do you see what I'm saying?
I do. All right, thank you.
Okay.
Thank you.
I'm going to touch on the Qatar case, and this is not a one-size-fits-all about sexual imposition and this offensive or consent. The Qatar case, this was a woman who was sleeping, so there was no ability to consent, and this would have been offensive because there was no prior sexual history between the two, which is not the situation in TC's case.
So
And
is the best practice then to approach this case by case and have consent hearings if necessary?
I think it has to be approached case by case. If there is enough information in the record to determine if there was consent, certainly the court can make the determination. If not, there are numerous cases that indicate that a hearing would have to happen, or there was remand by an appellate court for such a hearing.
And was there enough evidence in the record coming out of this trial to establish whether there was consent or not?
When there was a question specifically asked as to the alleged rape about whether it was consensual. There was no question asked about consent as to any sexual contact with touching.
What about the text messages? Do those play into the consent question?
It was not clear what he was agreeing or admitting to or apologizing for, and because there were other reasons for his apology, but the nature of her clothing combined with the past sexual relationship between the two, I think in this case there was either enough information to show that this had to have been consensual if anything happened, or the court would have needed to have a hearing on the issue of consent. As to the magistrate did not make any clear findings about KS's attire as to the sexual imposition, and that would have been another factor that had the trial attorney raised this issue, this could have been reviewed not only in front of the judge, but then on appeal, where there would have been a likelihood of reversal even at the appellate level. TC should have been exempt from classification under he met all of the elements for that classification. And even in the Raybar case, even though the specific issue wasn't analyzed, that applied to a charge of sexual imposition when there was no finding of a lack of consent. We asked this court reverse the juvenile court's decision, vacate TC's adjudication and classification, and remand this matter back to the juvenile court for further proceedings. Thank you.
Thank you. Thank you. We will take the matter under submission and issue a timely written decision. Enjoy the rest of your day.
Thank you.
The second case before the court this morning is C-24-0338, Ho versus Co. Good morning. Would you like to reserve time for rebuttal?
Yes, Your Honor, 5 minutes, please.
You may begin when you're ready.
Good morning, Your Honors. Chachi Ho for appellant. May I please the court? Mother is grateful for this opportunity to be heard. As Judge Kingsley stated, perhaps given how costly the proceedings wound up being, if you recall, $150,000 of guardian ad litem fees. Mother represented herself in this appeal. While pro se litigants are held as standards as parties who have attorneys, court also entertain all cognizable argument that unrepresented litigants present in the interest of fairness and justice. Thank you. Most of all, Mother thanked this court for reversing 4 cases. First, improperly sentencing her to jail for 60 days to compare guardian ad litem fees. Second, improperly awarded additional guardian ad litem fees related to his participation in the appeal. In addition to this jaw-dropping, shock the conscience, $150,000 guardian ad litem fees. Third, improperly label her as a vexatious litigator. Fourth, improperly order her to pay father's attorney fees. These reversals form the backdrop of this appeal, and Mother is requesting this court to reverse the contempt and jail sentence and refund the improperly collected interest payment for the following reasons. First, the trial court order on interest was defective, and the trial court improperly sentenced Mother for not to complying with this defective order. Why is this order defective? Let's look at this order we're appealing here. This order we're appealing here, which is on May 13, 2024, stated, the court finds that the plaintiff has not paid interest totaling $25,000 on the equalization payment. As ordered. What order are we talking about? This is talking about the order dated November 13, 2023. That order stated, that order came out after the first district court opinion in C220319. the first district affirmed the equalization, but it didn't mention anything about interest. So after that first district opinion, Judge Searcy recused, and the new judge, Judge Sonderman, who perhaps is unaware of the case, made this new order in response to the first district remand. So on November 13, 2023, Judge Sonderman stated, "Mother shall pay father the amount of $368,000 before the hearing on November 21st, 2023, which is 8 days for a large sum, but this is not an issue here."
Dr. Ho, where did the interest come from? Did someone file a motion for interest to be assessed?
That is a very good question. I think this is part of issue here. This interest was mysterious appeared, and the amount was not calculated, how it's calculated, why it's occurred. It's in the court record, for example, in the November 13 order, it says she also owes interest at the rate of 3%. It's really, Judge Kinsey, you're correct. It's unclear where it comes from. There was no deadline for payment of this interest. And there's no amount. It says you should pay an interest of 3%. There's no basis what statute the court used to access this interest. And the first district only affirmed equalization, but the first district did not mention anything about interest. So this was added by Judge Sonderman, and it wasn't clear where it come from. And it wasn't clear what this order means. Does it mean no interest if the equalization is paid before this deadline of November 21st? Does it mean interest will be assessed after the deadline? Or how is it calculated? I think this is a fundamental question. The interest wasn't there in the divorce decree. And it happened in this November 13 order, which does not comply with the first district remand. There was no interest, and there was really no amount, how it's calculated, what is based. And it's an order nobody could follow. It was unclear. It was just not an order. There's just nothing to follow. There's no deadline, no amount, and where it come from. So it's just very hard to see how mother can be fined contempt of an order that just stated she also owes interest at the rate of 3%. That's all it says in the order.
And do you know, Dr. Ho, when did the interest begin accruing? Was it from the date of your divorce decree or from the remand from this court when the equalization payment was upheld? Do you know when it started to count on the balance?
According to this order on November 13, there's no way you can tell because it says it also owes interest at a rate of 3%. So it could mean it's accrued from that court order date, November 21st, 2023. I mean, nobody would imagine it would occur from the divorce decree because it's a different judge, and it's hard to imagine a new judge will come and remand the case from the first district, which have no indication of interest should be assessed, to add additional interest, and it's back calculated, and it's very unusual. Also, it's the procedurally, if you look at the document, more information comes later after this court order in November 13. So the opposing counsel, Sarah Fox, filed a motion to clarify. As you said, it was unclear where this interest comes from, how is it calculated. But in this motion to clarify, the opposing counsel also drafted the order in which she admitted she drafted order to remand the original statement on November 13. She also owes interest at a rate of 3%. And on February 7, she drafted the order for the court, and court basically just rubber stamped it to amend it to read as she also owes interest rate of 3%. But in addition, it added effective date back to December 20, 2021, and compound annually. But this is this is opposing counsel's words. And the Ohio Supreme Court.
Dr. Ho, if the trial court had reviewed that proposed order that opposing counsel had drafted and determined that what she had included, the terms she had included, were correct and proper, is there still a problem?
Indeed, Judge Bach, you're right. If the trial court have reviewed it, have a chance for a hearing, have discussed it, have explained it, have a chance for me to ask questions or clarify what does it even mean, because even in this order, there was no amount. So there was some terms, but there's no amount. And this was never given a chance for hearing, for argument, because this is a motion to clarify. So this motion is only asking the court to clarify. It's not a motion to set the interest to start at a certain date or set the interest to have certain terms. So the motion is for the court to clarify, and such there's no chance for mother to a chance to be heard. It's a motion to the court to clarify, and it's not a motion to discuss the interest. And Ohio Supreme Court has ruled that in this Supreme Disciplinary Council versus Bailey, the court committed prejudicial error by delegating responsibility for the content of the opinion. It's the content. And Supreme Court vacated and remanded the case in State versus Robert. So this order for clarification that perhaps smartly drafted in a way just to the court and then submitting a court order directly to the court that mother have no chance to look at it, talk about it, and the court literally just stamp it and adopt whatever the opposing counsel requested. There's a prejudice in the outcome, as we talked about earlier in the previous case. And but even if there were no these prejudice outcome by the opposing counsel, or the order was not defective, it's clearly stated $25,000 for a certain deadline, which is not the case here. But even if they were true, the court have not identified any statutory basis that would support the word of interest in this case. And particularly, it contracts the Supreme Court opinion in which it mentioned that a trial court cannot add interest to a property division award when the decree does not specify interest. In Coe Jail versus Coe Jail in 1982, number 81-865, the Supreme Court clearly stated a deferred monetary obligation in division of marital property does not bear interest. And in Wolfe versus Wolfe in 1976, property division in divorce are final orders, and that court cannot be modified after judgment. And this implies also to the interest, especially this case, in the divorce decree, there's no deadline for the equalization payment. So the equalization payment is a certain amount, but it doesn't specify a deadline. And it's reasonable to expect people cannot come out with the equalization the same day the order was given. That's a huge amount. So
And
there's no deadline.
Dr. Ho, you're out of time.
Thank you, Your Honor.
Thank you. Good morning.
Morning, my name is Carlos Coe. I'm not even sure where to start.
Could you speak up a little bit?
Let me get closer to the mic. So I assume you are very aware of this case. You have gone through so many of these appeals, and have also reconsidered the ruling on your appellate on the divorce decree. The equalization, property equalization, did have a fixed deadline of December 20th. That was about roughly 3 months after the divorce decree was issued.
And was that in 2021?
Yeah, I mean, it might be. I don't have all the numbers. You have all the information there. Right? And so what happened is, before there is a deadline, before that deadline, I signed over my ownership, half ownership of that home, worth currently about $690,000. I signed that over. So that was back in 2021, a long time ago. She was supposed to pay a sum. This court is also aware of exactly how much that sum is. And she withheld $368,000 of that sum. Okay? She has in her own full ownership a $690,000 home. And the lower court, the divorce court, is aware that she has a home equity line of credit that could easily cover that $368,000 she owed. So what happened is that this court, even after it had, so to start with, when this court looked at the appeal for the property, this court could not see any details of why that should even be appealed, and this court looked at it independently. It's written in the appeal. This court did that, and it was also reconsidered, and this court again upheld the property equalization. After this court has upheld the property equalization, she refused to pay the property equalization, simply flat out refused, even though she has a home equity line of credit and full ownership of that $690,000 home. So let me read here. So ultimately, I'm not sure exactly what happened there. So ultimately, she did pay the $368,000 of property equalization because she had all the means to do that. Okay, I don't want to go into more details of how it's so obvious she had the means to pay that, but she simply refused. Okay, and this court, by the way, right, had already ruled and then reminded on August 19, 2024, that this appeal is supposed to be limited to the May 14, 2024 entry imposing a 10-day jail sentence for contempt of court related to that equalization payment. Now, what happens is the appellee has absolutely no difficulty making these payments. And so the appellee, I want to just say that appellant paid the property equalization with interest on 18 July 2024. The contempt was purged, and she has never spent a minute in jail. Essentially, every single time when the payment is due, she easily pays it because she has more than enough resources. She has repeatedly claimed difficulty in making payments and so forth. By the way, I need to inform this court. She repeatedly brings up the gal of $150,000. I paid half of that. I paid half of that. My legal fees on this, excluding the gal, total close to $250,000. That's how much I have paid. Okay? And maybe, I feel like I'm a man, and I have been faced with two lower court judges that are female, and this court, I feel kind of awkward. I don't know, if you see, how I feel about this, okay? Please understand that the way this is started was two police officers coming to my home and yanking me out of the home in the middle of COVID. Okay, please understand that. Before vaccines were even available, I was yanked out. She gave me access to an electric car back then that had no charging, no ways of charging. So I was yanked out of the home with no transportation. I had to beg the police officers to drop me off at the Enterprise so I can rent a car. I was in a hotel with everybody coughing all over me. It was almost like a death sentence. Please understand this, okay? I had to scamper enough cash to hire an attorney, right, to go through that domestic relation, what do you call it, domestic violence and so forth and so forth. You have already seen how this has worked out with our son and the details of that. You can see that for yourself.
And your son now is almost 18, is he not?
He is. On April 20, he'll be, I'm sorry to say, but soon he will be 18. And he knows every single detail about this, okay? You can appeal all you want, but eventually, when it comes to that, he knows all the details. There's no way you can, I don't know how to say the English word for that, but I'm really going way too far. So going back again to this, basically is that this thing has already been paid for. I don't even know why we are here. I think she wants to say something. Oh, by the way, if that $368,000 that this court upheld and the lower court said, if you had simply held that money in a bank, like I use Ally Bank, the interest I would have earned on that just from a straight bank account is roughly equal, if not a bit more, than that 3% interest rate, by just simply holding on to that money. Now, in her case, if she had to do a HELOC, she would have to pay a considerably a bit higher interest rate, probably maybe 5%. I don't know what the mortgage rates are nowadays. But by simply withholding the money from me and making me go through all the hoops of hiring an attorney to try to do it, I've given up with an attorney. So you have seen my attorney come here. Like every single minor detail that my attorney makes or someone makes, this court overrules. I can't afford that. Okay, I can't afford that anymore. And so I've stopped. And I think this court is also aware that she has had at least 2 semesters of law school at University of California, San Francisco. At least 2 semesters. And in the meantime, she continuously files motion in the lower court about parenting time. She's not around. She's doing law school in San Francisco, of all places. Why not in Cincinnati? Why not in Kentucky? But then those motions cost me so much money. Anyways, I think I should stop. I'm really diverting way too far from just this very simple. You saw my response. It was half a page because that's really all there is to this. Okay? Whatever financial difficulty she claims, I've been hit at least as badly. Okay? And I'll stop here. I have nothing more unless you guys have questions. Okay.
Thank you very much.
Thank you.
Thank you, Your Honors. As we spoke earlier, interest is against the Supreme Court ruling. But according to what you mentioned about, as Judge Kingsley said, the trial court set mother up to fail. When the trial court held contempt for equalization payment in abeyance while compelling this shock the conscience guardian ad litem fees under the threat of incarceration, mislabeled me like vexatious, such that I have no option to file motion to stay, reconsider, whatever legal route I have.
But even if that designation had been upheld, and if the court, a vexatious litigator can always ask the court for permission to file something, correct?
Yes, Your Honor, Judge Bach, you're right. But the timing was just too late. There was a jail sentence together with this vexatious thing. By the time I would have a hearing, I would be jailed. In addition, I have no idea how much to pay. You see the court order. It says 3%. It have no details. That $25,000 has never occurred in any of the court order until I'm thrown into jail. And
So are you asking us to remand the case to have a fixed amount of what the interest is so that you would know what to pay? Is that what you're asking us?
that's the minimum. But if you reverse it, the trial court have to consider all the different Supreme Court opinion, whether interest should be assessed, whether.
Well, Dr. Ho, wasn't there an order that you were to purge the amount by pay, or purge the contempt by paying a specific amount on a certain date? It's like 27,000 and some change. Where did that specific amount come from?
There was never a court order specify that amount, where the court order on February says 3% compound annually, and the court order on November says 3%. And there's no specific amount at all in any of the court records. It was only in the.
Did you make a payment in order to purge the contempt?
I did, but that was not voluntarily. So
But how did you know what amount of money to pay?
Because there's this this order that threatened me to jail, and it didn't tell me what amount to pay. It just said 3%. So I made the order according to the order that I need to pay. I was already sentenced to jail. After I was sentenced to jail, then I pay whatever. I have no idea where that number come from. I have an option of going to jail. I am vexatious. I cannot appeal. And it was just under huge duress. I have no idea, but my option is just going to jail.
So you paid what they told you to pay?
I
though.
paid the amount under huge duress, with the jail threat, with the vexatious litigator, not knowing the amount, not knowing how it's come from. I lost all my recourses. So, and also, the trial court set me up to fail as previous opinion. But most important, I want you to think about today's implication for your decision. What if today a citizen violated traffic and the court order you will go to jail or fine $100? But it wasn't clear how many days or get a fine without a payment number. And subsequently, the prosecutor can come back and say, oh, you can go to jail for a lifetime, for motion for clarify, and let me draft a court order for the judge, and Judge rubber stamp it. You didn't challenge the initial order because it says you can go to jail. You thought it's a day, but it's a lifetime. And the prosecutor could say, instead of $100, it's $1 million. So this procedurally could put anybody to a lifetime jail. And if the court opinion is this kind of duress and contempt does not need to be corrected in the future, the legal system is just being challenged because the person does not know what's the court order, what's the punishment. It's 3%, no amount. The person have no words to say when there's a motion to clarify, and the opposing counsel significantly increase to the terms that benefit the opposing side. And then a contempt together with the vexatious, not knowing the amount, not having a counsel, and forced to pay under duress would result something that cannot be corrected. I don't think there's anybody safe from imprisonment or warranty the protection of the legal system. If the system can be stepwise, each step is a minor infringement. Each step, the first time, unclear orders. Second time, clarified by the opposing counsel. Third step, contempt. Once it's paid, it cannot be corrected. Then I'm concerned it wouldn't just impact me, but everybody. Thank you, Your Honor.
Thank you. We'll take the matter under submission and issue a timely written decision. Enjoy the rest of your day. The court will now take a brief 5-minute recess.